Good morning and welcome to today's New York City Council hearing on the Committee of Rules, Privileges, Election Standards, and Ethics. At this time during today's hearing, no one may approach the dais. If you'd like to testify, please see one of the Sergeant-at-Arms to fill out a testimony slip. Please silence any electronic devices. Chair, you may begin.
Good morning and welcome to this meeting of the Committee on Rules, Privileges, Election Standards, and Ethics. I'm Councilmember Sandra Ong, Chair of the committee. Before we begin, I would like to recognize the other members of this committee who are present. Councilmember Elsie Encarnacion, Minority Leader David Carr, and Majority Leader Sean Abreu. I'd also like to acknowledge the counsel to the committee, Jeff Campagna, and the committee staff that worked on the appointments we will hear today. Chief Ethics Counsel Pearl Moore, Director of Public Integrity, Francesca Della Vacchia, and the Deputy Director of Public Integrity, Alicia Vassal. By the letter dated January 30th, 2026, Mayor Zohran Mamdani requested the advice and consent of the Council regarding the appointment of Stephen Lafredo to the New York City Conflicts of Interest Board. Today, we are meeting to hold a public hearing on this nomination. The Conflict of Interest Board is the entity that serves to provide clear guidance to public employees regarding the conflict of interest laws, codified in Chapter 68 of the New York City Charter. The board is tasked with achieving this goal through training, education, and the issuance and publication of advisory opinions relating to the conduct that may violate the city conflict of interest law. The board also adopts rules to implement and interpret the provisions of the conflict of interest laws. It reviews and adjudicates alleged conflict violations and has the power to impose penalties, including fines up to $25,000 per violation and suspension or dismissal of the city employees when deemed appropriate. The board also collects and reviews financial disclosure reports. The board consists of 5 members, 3 of whom are appointed by the mayor, 1 appointed by the public advocate, and 1 appointed by the controller, all subject to the advice and consent of the city council. The mayor must designate one of these members as chair of the board. The charter states that all members should be chosen for their independence, integrity, civic commitment, and high ethical standards. Board members serve for staggered 6-year terms and are prohibited from serving more than 2 consecutive 6-year terms. Board members are required to meet at least once a month and are prohibited from holding public office, seeking election to any other public office, being a public employee at any jurisdiction, holding a political party office, or appearing as a lobbyist before the city. Board members are entitled to receive compensation in the amount of $250 for each calendar day they perform work for the board. The chair is entitled to receive $275 per day of service. Today, we are joined by Stephen Lafredo, who has been nominated by the mayor for appointment to the Conflict of Interest Board. Mr. Lafredo served as a staff attorney at the Legal Aid Society from 1982 to 1986. From 1986 to 2024, he was a law professor. From 2023 to 2024, he was a professor at the City University of New York Law School. He received his BA from Yale University as a graduate of Harvard Law School. If the council grants its advice and consent, Mr. Lafredo will be appointed to serve a 6-year term beginning on April 1st, 2026 and expiring on March 31st, 2032. Welcome, Mr. Lafredo, and thank you for being here today. Please raise your right hand to be sworn in.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this committee and in answer to all council member questions?
I do.
Thank you.
May I proceed? Good morning, Chair Ong and members of the committee. My name is Stephen Lafredo. Thank you for the opportunity to address you concerning my nomination by Mayor Mamdani to the Conflicts of Interest Board. The board's mission as an independent entity promoting ethical and accountable government is a profoundly important one. It's essential to fostering public trust and confidence in city government and in the rule of law. My decades of work as a public interest attorney and as a law professor training generations of public interest lawyers reflects my longstanding affinity with and commitment to these values. I would be honored to serve on the board and work to advance its mission. I have deep roots in and love for this city. I was born in the Bronx, the place my grandparents immigrated to from southern Italy. My wife, Helen Hershkopf, who joins me today, was born in Brooklyn to a father who immigrated from Poland and a mother whose family arrived here from Ukraine. Our son, Ben, was born in Manhattan, where he continues to reside. I've devoted my entire professional career to public service and public interest work in New York City. Immediately following a judicial clerkship with the New Jersey Supreme Court in 1982, I entered practice as a staff attorney at the Civil Division of the Legal Aid Society in the South Bronx. While there, I represented hundreds of individuals and families and also litigated impact cases with my colleagues, including the first generation of cases establishing a right to shelter for homeless families. As pro bono counsel to the Urban Justice Center, I continued to represent large groups of vulnerable New Yorkers and was recognized by the Association of the Bar of the City of New York for, quote, extraordinary dedication and outstanding performance, unquote, in advancing the legal rights of poor people in New York City. I served for 38 years on the faculty of CUNY Law School, an institution dedicated to the public interest and widely regarded as the leading public interest law school in the nation. In addition to teaching constitutional law, I founded and directed 4 clinical programs providing legal services to underrepresented communities throughout New York City. That service took the form of individual representation, collaboration with community organizations, policy advocacy, and impact cases. Some of this work was done side by side with lawyers from the city and the state. For example, through our Immigrants' Rights Clinic, I served as lead counsel with the City of New York and the State of New York as co-plaintiffs in a years-long litigation against the federal government, challenging illegal restrictions on the immigrant amnesty program of the Immigration Reform and Control Act of 1986. Later, I founded the Economic Justice Project in response to certain harsh and unlawful welfare policies that arose in the 1990s, policies that drove thousands of low-income CUNY undergraduates out of college and into dead-end workfare assignments. Many of these students were single parents, striving to obtain the skills and credentials needed for living wage jobs that could lift their families out of poverty and alter the life chances of their children. Together with community partners, we fought that battle for over 15 years, enabling countless students to earn their degrees and securing policy reforms that allowed CUNY to more fully serve its historic role as an engine of economic mobility for the people of New York. The National Clinical Legal Education Association honored our work with its award for excellence. Lastly, I directed the labor docket of CUNY's Community and Economic Development Clinic and its Workers' Rights Clinic, both of which engaged in a broad array of labor and employment representation on behalf of low-wage workers, most often immigrant workers whose circumstances made them especially vulnerable to exploitation. All of these endeavors have sought to advance the well-being of New York and New Yorkers, in most instances by holding government accountable to the law. This has been my life's work, and in the course of that work, I've instructed hundreds of clinic students handling actual cases in the ethical practice of law under the rules of professional conduct. And I've developed deep expertise in administrative law, adjudication, due process, and judicial review of agency action, expertise directly relevant to the functions of the Conflicts of Interest Board. Serving on the board would give me the opportunity to continue to work in the public interest and to advance the board's mission of promoting fair, honest, and accountable government, a mission I strongly believe to be of the utmost importance. Thank you, and I'd be happy to answer your questions.
Thank you, Mr. Alfredo. I'd also like to recognize Deputy Speaker Williams, who have joined us today. So I do have some questions before going to the other members of the committee. In your written responses to the pre-hearing written questions, you wrote that you were recommended for this position on the Conflict of Interest Board by the Chief Counsel to the Mayor, Ramzi Kassem.
That's correct.
What is your relationship to Mr. Kassem?
Mr. Kassem and I were colleagues on the faculty of the CUNY School of Law.
Were you solicited expressly for this position, or do you also pursue other positions in administration?
No, I was asked if I would agree to be nominated to this position.
Thank you. Sorry, I also like to recognize Councilmember Krishnan joining us today. And because now we have quorum, I also like to recognize Councilmember Kevin Rowley, who's on remotely. Sorry, back to the questions. Your resume indicated that you are or were a founder and board of the member of the Party for Humanity. What is that, and what is the nature of your involvement, and does it still exist?
It does not still exist. It was an organization that my young son thought up to deal with the situation of young children getting many gifts for birthdays, and there being a better way to deal with that situation, which was to organize donations to small charities in lieu of gifts at children's birthday parties. The organization no longer exists.
Oh, that's nice. Are you or anyone you're associated with currently a member of any organization that does business with the city?
Yes, I sit on the board of the Urban Justice Center, which has a number of contracts with the city and also occasionally sues the city. And my wife, Helen Hirschkoff, also sits on that board. Helen is also a professor at NYU School of Law, which I believe does some business with the city.
So were you advised to seek guidance from the Conflict of Interest Board before this hearing?
Yes, and we received advice both with respect to my position on the Urban Justice Center and with respect to Professor Hirschkoff's position at UJC and her service on the faculty of NYU Law School. And the advice from General Counsel was that I would not be precluded from continuing to sit on the board because I'm not a regular employee. However, I would have to recuse myself and have agreed to recuse myself in any matter that comes before the board that involves UJC, and also to recuse myself from any discussions within the UJC board that has anything to do with COIB.
Thank you. You were asked on your pre-hearing questionnaire whether you have experience or expertise in municipal ethics law, meaning Chapter 68 of the charter. So we're just going to try to get a little bit more answer to that. Can you just give us a little bit more answer than what was said in the questionnaire?
Yes, I have not had direct experience before the last few weeks where I've been poring over all of these statutory provisions and regulations. I do have experience with the state ethics law because as a member of the CUNY faculty, I was holding policy making positions and so was subject to the disclosure requirements. And also because all of us were trained in the strictures of the state ethics law as employees of CUNY. Having said that, I've had over 4 decades of experience as an attorney governed by, well, when I was young, it was called the Code of Professional Responsibility. Now it's called the Rules of Professional Conduct. Which, as you know, is a comprehensive scheme of ethical requirements governing lawyers in this state. The code and the rules don't perfectly match, obviously, with Chapter 68, but many of the basic principles are the same. Confidentiality, conflicts, that sort of thing, they share principles.
Thank you. So just a follow-up to this. So as experience as a law professor, do you have any experience as a law professor relating to the missions or duties of the Conflict of Interest Board?
I'm
sorry, I know, just a lot. How does your experience as a law professor relate to your mission and duties of Conflict of Interest Board?
Well, in 2 ways. First, as I wrote in my response to the pre-hearing questions, I'm an expert at administrative law, administrative adjudication, due process, judicial review of agency actions. I've appeared at over 1,000 administrative hearings and been involved in many lawsuits challenging agency action, both rulemaking and decisions after hearings. And so I have deep expertise in that area, which is in those areas, which is directly relevant to the workings of the Conflicts of Interest Board, since they are an agency that does rulemaking, makes decisions after hearings, subject to judicial review. I also have over 30 years of experience teaching CUNY students through its clinical program, in which the students handle actual cases under the supervision of faculty. And so I've trained hundreds of law students in handling actual cases in the ethical practice of law under the rules of professional conduct.
Thank you. I'd also like to recognize Councilmember Lee, who has joined us here today. Back to the questions. You have spent your entire career as a law professor and have dedicated a substantial amount of your professional life to defending the rights and improving the lives of people with very low income. What experience do you have with the government service that makes this position interesting to you and that makes you particularly a good fit for this position?
Well, as you just mentioned, I've devoted my entire life to public service and public interest. Serving on the board would give me the opportunity to continue along that path. Public service, as you all know, is very meaningful work. It's a noble pursuit. It'd be an honor for me to be able to continue to contribute in that way.
Thank you. According to your written responses, you have appeared in over thousands of administrative hearings, and you have litigated numerous Article 78 cases challenging agency regulations and determinations. Have any of those appearances or representations been before COIB or oath in behalf of a client accused of violation of a Chapter 68?
No, they have not.
Okay. When asked whether there should be established penalty structure for a COIB violation, you cited the federal sentencing guidelines for the principle that rule-based penalties might hinder the board's ability to arrive at a disposition that best promotes the goals of the ethics law. Please explain what are the goals of the ethics law and how a rules-based penalty schedule might hinder them.
So one of the Of course, there are many aspects to what the board would try to accomplish through Chapter 68. One, of course, is to hold public servants to a high ethical standard. Another is to administer the law in a fair way. And the question that was posed in the pre-hearing questionnaire is essentially asking whether it's better to have a very narrow rules-based system for administering the law, or rather to have a more open standards-based system that allows for, allows for more flexibility, allows the board to take more of a totality of the circumstances kind of approach. There are benefits and drawbacks to both approaches. You recited the drawback, one of the drawbacks to a narrow rules-based approach, or having a fixed schedule of penalties, which is that when developing such a schedule, it may be difficult to anticipate the myriad factors and combination of factors that a particular case might present, and it may prevent the board from ruling in a way that it believes is most fair and most just. And that was the criticism that many federal judges had of the sentencing guidelines when they were mandatory. There's a disadvantage to having a more open system, which is it could give rise to what appear to be arbitrary variances between facially similar cases. And so it's a question that sitting here today, I wouldn't want to prejudge before having an opportunity, if I'm confirmed, to raise these issues with staff and other members of the board and discuss them. I agree it's an important question and does deserve examination by the board.
Thank you. You were asked whether there should be a statute of limitations for the violations of Chapter 68. We responded that you would need to understand the reasons that the chapter omits a statute of limitations period from the Chapter 68 before you could opine on such questions. And you wrote that you have no opinion on whether the board has the power to adopt a statute of limitations of its own accord. So as a threshold matter, would you acknowledge that if the council wanted violations of a Chapter 68 to be subject to a statute of limitations, the council could amend Chapter 68 to include that?
I believe so.
Okay.
I believe that might, I'm going to take a guess. I believe that might have to be done through charter revision or the state legislature. I do not know if the council has the authority to do that.
Okay. Okay, so we do. I just have
do.
confirmation
I'm glad
that
to
we
hear that.
do.
Makes
So
things-
we do. So we do have the ability to do that. So if so, then your answer would be yes, right? Am I surmised that like that? That's what you just said.
So
Yeah.
on my opinion on the ultimate question,
Yes.
my opinion on the ultimate question is, all things being equal, there ought to be statutes of limitations in situations like this, because otherwise you might face the unfairness of a claim being, or a complaint being brought against someone many years after the fact, after, what's the famous quote, after, witnesses have disappeared, memories have faded, evidence is no longer available, it's then impossible for the person to set up any kind of meaningful defense against the complaint. So again, all things being equal, I think there ought to be a statute of limitations. But let me repeat my caveat, which is there are things that I don't know. I don't know whether this was, the question of statute of limitations was raised when Chapter 68 was adopted. I don't know what the arguments were against it. I don't know if the fact that a statute of limitations is missing was intentional or an oversight. And so before taking a firm position, I would want to educate myself about
No,
those
I
things.
understand. So, but I think the question is more of whether or not the city council, because that if we want to have a violation of Chapter 60 subject to the statute of limitations, we could amend it as a council who has the authority to do so.
It appears that committee council seems to have the answer to that. I
Yes.
don't know the answer to that.
So what deterrent effects could the absence of a statute of limitations have on public corruption?
What,
Like if you don't have one, if you don't have the
no
statute.
statute of limitations?
Right.
Then someone who committed a violation would have to live every day out into the future wondering whether the COIB would catch up with them. I don't know how much more deterrence that would, deterrent effect that would have, and whether it would outweigh the potential unfairness of having no statute of limitations.
Well, since we're going to get to the real situation now. So discovery, adjudication, or betrayal of public trust often takes years. Also, violations often involve a public official using public resources for private benefits. So, for example, in 2023, the COIB ordered Mayor de Blasio to reimburse $320,000 to a city for the use of NYPD for security during his 2019 run for president. Given these realities, what benefits to the public trust would there be if public officials could escape penalties with the passage of time?
You raise an excellent point. And so the question about if there's a statute of limitations, one would be, well, what's the length of the statute of limitations? So the limitations period in the civil service law for discipline is something like 18 months, which is very short. A statute of limitations for Chapter 68 could be set much longer. There could also be provisions for tolling the statute of limitations under certain circumstances.
Thank you. I might have more questions, but I'm going to actually hand it over to our Minority Leader, David Carr.
Thank you so much, Chair. It's good to see you, Mr. Lafredo.
Thank you.
I just want to pick up with some of the questions that we discussed the other day, and I'll start where I did in that conversation with respect to COIB's former social media presence. The Conflicts of Interest Board used to have a very engaging, entertaining, and informative presence on social media, in particular X, then known as Twitter. Around 2023, that platform, that account disappeared. And so I'd just love to know your position on, whether or not you'd advocate for the return of COIB's presence on that platform and other platforms so that the public could get the benefit of the agency's staff and expertise.
Well, I think as we discussed, I was not aware of this particular issue. Of course, in general, the more the public can be made aware, the more the public servants in the city can be made aware of the strictures of the ethics laws, the better. Sitting here today, what I can assure you is this is an issue that, if I'm confirmed, I would raise with other members of the board.
Appreciate that. And I just want to double up on what the chair was asking earlier about, a statutory framework with respect to penalties and making sure that there's some level of consistency across cases. Obviously, I heard your answer, and we spoke about this previously, but do you commit to doing an internal inventory or talking to your colleagues, future colleagues on the board, about an inventory to assure that there's some level of consistency despite the discretion that COIB currently has under law?
Again, I thank you for the question, because I think it's a very important issue. And one place I would want to start is to look at the board's existing precedents and see how the penalties match or don't match the violations, and whether there's consistency or variation, and why that is. And then discuss with staff and other board members what steps to take from there.
Appreciate that. And, obviously, we have public servants, longtime agency staff, elected officials, and everything in between, agency heads, right? And there's a diversity of opinion that exists in the city workforce, all those who are subject to Chapter 68. And we all come here as policymakers, and you prospectively as one, with a lifetime of opinions, right, that you've had time to develop. And I just want to hear from you about how seriously you take the commitment to kind of leave your own ideological views at the door when you're assessing matters that come before the board.
Yes, thank you for the question. I think politics, ideology, partisanship have absolutely no place on the board. Giving entrance to any of that would be anathema to the entire purpose of the board, and would undermine its credibility and the public's trust in it.
I appreciate that answer. That's all the questions I have for now, Chair. Thank you.
Thank you. I'd like now to turn it over to Deputy Speaker Williams.
Hello.
Hi.
Okay, the first question I have is, do you favor a structured fine schedule or broad discretion?
So that goes back to the questions that the chair asked. And again, I see advantages and disadvantages to both approaches. The advantage to a fine schedule is that it gives clearer notice in advance. It also would tend to produce more consistency across cases that, look facially similar. The downside is that it may hinder the board or prevent the board from reaching the most fair, the most just result in a particular case that involves many factors that perhaps the authors of the fine schedule did not anticipate. The advantage to having a broader totality of the circumstances kind of method for imposing fines is that it, again, gives the board the opportunity to reach the fairest disposition, potentially reach the fairest dispositions. The downside is it could give rise to what appear to be arbitrary inconsistencies between cases that are similar. And so I see benefits and drawbacks to both of those approaches. I agree it's a very important matter, and I would want to, if I'm confirmed, I would want to have conversations with staff and other board members about this.
Thank you. Do you think there should be a statute of limitations on ethical violations?
Yes, so as
Nancy does
well,
Oh, okay, sorry.
say it again?
Sorry. You don't have to explain it again. I'll go to the next question. And I know I did hear you talk about your career litigating against government. Do you feel like you would ensure neutrality in enforcement decisions?
That I would,
Ensure neutrality in
Neutrality.
Enforcement. Yes.
yes, I can assure you I would be neutral in that regard. In most of my career was dedicated to holding government accountable to law, and that's, in a way, what the COIB does. It's holding public servants to a high ethical standard. I don't think there's any contradiction or tension between that task and what I've done throughout my professional career.
And in your opinion, do you think there are any current weaknesses within the Chapter 68 law?
I am, before having the chance, I've pored over this statute for the many hours over the last number of weeks, read the rules, read a number of the decisions. I think before, again, if I'm confirmed, before I have an opportunity actually to dig into and be involved in the administration of the law, I could not opine on potential improvements to Chapter 68.
Thank you. I know Councilmember Chris Banks have joined us here today, and I know he has a couple of questions too.
Thank you, Chair. Well, first of all, congratulations on coming before the committee. The COIB is sometimes required to rule on matters involving elected officials, senior agency heads, or mayoral appointees. How do you define independence in this role, and how would you ensure that this is exercised consistently?
Well, the board needs to treat everyone the same
Right.
when there's a complaint. An elected official, in some instances, reading Chapter 68, there's certain narrow, expressly enumerated situations where a different rule might apply to an elected official. Raising money, for instance, for a campaign. Other than those specifically enumerated and narrow circumstances, the board needs to treat any public servant in the same way with the same processes, equally.
Thank you. Have you ever declined a matter, a client, or a professional opportunity due to an ethical concern? And if so, what did that experience teach you about ethical decision making?
If I ever declined a matter, I mean, there may have been, in my 40 years, cases in which a client wanted the attorneys or the clinic to follow a particular approach, and we were unable to do that because of the code rather the rules of professional conduct. I've not declined a job.
Okay.
I was at CUNY Law School for 38 years, so there weren't many, intervention points where I was offered jobs or looking for jobs. So that really has not come up.
Okay. How do you strike the appropriate balance between protecting public servants from unfounded accusations and ensuring meaningful accountability when it comes to violations, when violations occur?
Yes, I think the Chapter 68 and the rules address that. For instance, with the confidentiality provisions, if a complaint doesn't go past a particular point, it's confidential.
Right.
For advice, it's confidential. Without that, the system really couldn't operate properly. Once there's an actual decision, then of course, if there's a decision that a violation has occurred, that does become public.
Okay. And at a time when, public trust in government is very fragile, what role should the Conflict of Interest Board play in strengthening confidence in cities' institutions?
I think it needs to scrupulously carry out the charge of Chapter 68 and the related ethics laws.
And when it comes to the situations about when it comes to educating the public, what makes you particularly well suited to serve on a body that is responsible for both educating the public servants when necessary, and also disciplining them?
Well, I've been an educator for 40 years, 38 years. Some of the work through the clinics has been know your rights kind of work out in the community, where we would have to take frequently complex legal rules and make them understandable by the public. Having said all this, I have examined the board's materials, its public education materials, its videos, and have to say I've been quite impressed with what they're doing, which isn't to say that if I'm confirmed once I get there, I wouldn't want to dig into that and see if there are ways that I could be helpful and improve that part of the board's charge.
Well, thank you for that. This is my last question, Chair. The mayor appoints 3 of the 5 members of the Board of Conflicts. And how would you help ensure that the board maintains its independence from appointing authority while carrying out its duties?
Yes, well, thank you for the question. As you know, in 2019, the statute was altered to change the appointment authority from one that was exclusively mayoral to one that was divided, shared with other citywide elected officials. And the reason given for that was that it would improve the independence of the board. So that is a central, prime directive of the board.
All right.
Once someone goes on to the board, they're duty bound to apply the law to any public servant that comes before it, irrespective of the fact that it might be an elected official who appointed them. Same thing happens with federal judges, for instance. They might be appointed by a president. They sit on cases in which the president is a party. They should not let that influence them. And I can assure you, the source of my nomination would not influence me in carrying out the duties of the job.
All right. Thank you. Thank you for answering those questions. Thank you, Madam Chair.
Thank you. I'd like to now turn it over to Council Member Encarnacion.
Hello, good morning. I know a lot of the conversation has been around how do you operate within the confines of the charter.
Yeah.
And so my question really is, under what circumstances, if any, do you or should the board recommend legislative amendments rather than try to reinterpret existing provisions under the charter?
So the statute gives the board rulemaking authority.
Correct.
Which means it can essentially set policy in the interstices, in the gaps in the law. Without having thought about this before, my preliminary thought would be, if there's a point at which there's a large gap in the law and a decision through rulemaking would make a very significant policy change, the board might consider whether the gravity of that makes it more appropriate for a legislative body instead of an administrative body.
Okay. And because I'm thinking too in terms of how do you adapt or interpret conflict law to modern realities. We were just talking about the you all on social media, right? Social media plays a big role in what is
Yeah.
coming up next
Yes.
for all elected officials, how they monetize possibly, right, on social media, how they communicate on social media. And so I'm wondering, looking forward, how do you see this, the board adapting any interpretation of conflict laws to modernize it?
If confirmed, I probably would not be the board member people would turn to on questions of social media because
Fair enough.
I have no footprint or experience in that, but I take your point that it is an emerging or already emerged issue that needs attention.
Thank you.
Thank you. I just have a few more questions. So city employees under investigation by COIB have a statutory right to be represented by counsel. When asked by whether the city should pay for such counsel, you responded you were unaware of any authority of the board to prescribe the provision of counsel. Why do you answer it that way when the Chapter 68 expressly allow for the counsel?
Well, there's a question of right to counsel and then a question of right to counsel funded by the government.
Yes.
And so that's the differentiation. I'm aware that public servants who are union members frequently have counsel through their unions. So
Right now, actually, then that leads to the second question I have, which is, so when the city employees who are under investigation or prosecution of a suspected violation of Chapter 68, should they be provided with counsel at the city's expense?
across the board. What I would say, and what I did say in response to the pre-hearing questionnaire is, as a general matter, if somebody is faced with a legal proceeding, and there might be a deprivation of a property interest or a liberty interest or their reputation, they ought to have access to counsel. And the reason that is because it promotes fairness. It also helps the decision-making process to have counsel on both sides. Because when there's counsel on both sides, there's a greater chance that the decision maker will be presented with the best facts and the best legal arguments supporting each side and be able to make a more accurate and fair decision. So if there's a reason why someone is unable to afford counsel, as a general matter, I think it would be a good investment to ensure that they had that. Again, both for purposes of fairness and for purposes of ensuring the process operates properly.
Okay, so following up to that question, so if a person is accused of a violation of Chapter 68, accused of taking actions that's beyond the scope of their duties and violations, and there are other violations of laws and policy, does that disqualify them from representation provided by the city?
Okay, so let me try to understand. So there's an individual who's both accused of a violation of Chapter 68 and...
Well, the violation is that they took actions that's beyond their scope of their duties.
I see, and so
And
the
that's
question
not-
is whether that person...
Right, right.
So the premise of the idea of getting counsel is when there's a complaint. At that stage, before it's been adjudicated, it's just a complaint.
Right.
The person hasn't been found guilty yet. The question of whether they've actually violated the statute is something that would be determined through an adversarial hearing process. And for the reasons I gave before, it's better for both sides to be represented by counsel under those circumstances.
Okay. I mean, so following up to the legal concept of everyone has a right to, legal representation, there isn't a right to counsel in civil proceedings. I know there's a right, obviously, in criminal proceedings.
Right.
Actually, it's very limited, the rights that someone has in a civil proceeding to counsel. So COIB is at the end of the day, civil proceeding. So can we just follow a little bit of the thought process behind your answers?
Yes, there's no, the courts have already decided there's no constitutional right to counsel funded by the government in civil proceedings. The city council has decided in many cases, tenant protection, immigrant cases, to, as a policy matter, provide for such counsel.
Right, but so your answer is that still, like in COIB proceedings, that, that everyone has a right to a counsel?
A right? No. People do not have a, the question, as I understood it, was a question of policy.
Right.
Would it be better? Would the system operate more fairly and efficiently and justly if people had counsel in, especially when if it gets to the point of an adversarial hearing? And I think as a policy matter,
Okay.
the answer is yes. As a constitutional matter, the answer is there isn't a constitutional right to publicly funded counsel under in those proceedings.
Okay, thank you for the clarification. So my last question, I think several council members here did ask it, but just to be a little bit more specific. If appointed to the board, what would your position be on handling alleged conflicts of interest violations by the mayor?
The mayor is in the law defined as an elected official, same as any other elected official. Elected officials, except when there is a very specific carve-out, are treated the same way as other public servants. So the answer is the mayor gets treated the same way as anyone else if there is a complaint about a conflict. There's no special treatment.
Okay, thank you. Thank you for all your answers. So I want to thank you for joining us today and providing your testimony. You are excused. I think now we're going to move on to the public comment period. So I'm going to open up the floor for the public for comments. If you wish to speak, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. We ask that you please limit your comments to 2 minutes. Every written statement, please provide a copy of that statement to the Sergeant at Arms. Do we have any? Okay, seeing none, the public hearing on these nominees is now closed. I would like to again thank the nominees and the members of the public, the speaker, my colleagues and the committee council and staff, and the Sergeant at Arms. This meeting is hereby adjourned. Thank you.